Hello, all. Welcome back to Law Decode with M. In episode 1, we explored the basics of IBC, and today we go deeper into the actual process that decides the fate of a company and stress, which is called the Corporate Insolvency Resolution Process. So, whether you're a law student or a stakeholder, this episode lays down not just the law but the reality behind how CIRP plays out. CIRP is governed by Part 2, Chapter 2 of IBC, that is from Section 6 to 32, and the detailed procedures is driven by Insolvency and Bankruptcy Application to the Adjudicating Authority Rules 2016. These are the rules which governs the filings before NCLT, which is the National Company Law Tribunal. And then we also have IBBI, which is the Insolvency and Bankruptcy Board of India, Insolvency Resolution Process for Corporate Persons Regulations 2016. This regulation covers timelines, disclosures, IRP or RP's duties, voting procedures, etc. So you must understand the interplay between sections, rules, and regulations and how these form the three pillars of CIRP, which can complete the process of resolution. Now let's decode the CIRP timeline, not just the days but the legal support at each step. First is the application made to the NCLT. For that, default should be existing and that must not exceed rupees 1 crore. An application can be filed by a financial creditor under Section 7 of IBC, operational creditors under Section 9, or a corporate debtor under Section 10. An NCLT, upon receiving the application, can either admit or reject the application within 14 days. After which, an IRP takes over the company's management, which is the interim resolution professional, by replacing the board. So while then a moratorium period is being declared, which halts the asset transfers, the legal actions, and the supply disruptions. So within 3 days of IRP appointment, a public announcement is made, and this has to be adhered to Regulation 6, and he has a duty of inviting claims. Now, to look into the role of IRP, who's been appointed for up to 30 days, he or she has the duty to compile creditors' claims, forms committee of creditors, controls debtors' assets, admits or rejects the claims under Section 18 and Regulation 12. The CoC is formed within 30 days of IRP appointment, and this is under Section 21. CoC consists of financial creditors, and operational creditors may attend CoC meetings if they are owed above 10%, but they do have limited rights. Now, decisions require a minimum of 66% voting share, and approval by CoC is essential under Section 30, subsection 4. After which, appointment of RP takes place. So this is within 7 days of CoC formation, and RP gets appointed. And that requires a minimum of 33% quorum. Now, once RP is appointed, the RP manages operations and drafts information memorandum for potential bidders, and these are prepared under Regulation 36. Then he prepares an evaluation matrix, and eligibility criteria for that is issued under Regulation 36A and 36B. Now, resolution applicants, they submit expression of interest and then the full plans, and those plans must prioritize operational creditors, must be viable, and should also include governance details. Resolution plans are submitted and evaluated as per Regulations 38 and 39. Now, once CoC approves such resolution plans, that is with minimum 66% voting share, then the NCLT, which is the adjudicating authority, must sanction it for binding effect. Section 29A of IBC is an appropriate section which filters out ineligible bidders, for example, promoters or persons who are responsible for the default. Now, if no plan is approved by the NCLT, liquidation follows. Assets are sold, proceeds are distributed per legal priority. Or if the plan is approved under Section 31, the whole company goes into CIRP resolution. Upon approval, all the previous claims against the corporate debtor are extinguished to allow for economic revival and provide certainty to the investor, and this is called clean slate doctrine. You can also request for extension up to 90 days under Section 12, subsection 3, which is beyond the timeline. Now, this is the pressing question you need to ask yourself. Whether admission of a CIRP application under Section 7 of IBC is on discretion of the adjudicating authority or is it a mandate? So when you read by the lines of Section 7, the NCLT shall, within 14 days of the receipt of application, ascertain the existence of a default from the records of the information utility or on the basis of other evidence furnished by the financial creditor. Now, to bank upon this, the Honorable Supreme Court in Innovative Industries versus ICICI Bank and others held that the moment the adjudicating authority is satisfied that a default has occurred, the application must be admitted unless it is incomplete. And the same has been reinforced in the case of Krishnamurthy and others versus Bharat High-Tech Builders Private Limited. The adjudicating authority is empowered only to verify whether a default has occurred or not. Based upon its decision, the NCLT must then either admit or reject the application respectively. These are the only two courses of action which are open to the adjudicating authority in accordance to Section 7, subsection 5. The adjudicating authority on one hand cannot compel a party to the proceedings before it to settle a dispute. However, a two-judge bench of the Honorable Supreme Court in Vidarbha Industries Power Limited versus Axis Bank held that the fact legislature used may in Section 7, subsection 5, clause A of IBC, but a different word, that is shall, in otherwise almost identical provision of Section 9, subsection 5. It shows that may and shall in two provisions are intended to convey different meanings. It is apparent that legislature intended Section 9, subsection 5 IBC to be mandatory and Section 7, subsection 5, clause A of IBC to be discretionary. The adjudicating authority may, in its discretion, not admit the application of a financial creditor, even though Section 7 of the IBC may confer a discretionary power on the NCLT. Such discretionary power can never be exercised arbitrarily or capriciously, and that has to be kept in mind. A review petition, although, was filed against Vidarbha Industries case, and that was dismissed by the Supreme Court. Further, the Honorable Court in Suresh Kumar Reddy held that if NCLT finds that there is a debt, but it has not become due and payable, then application under Section 7 can be rejected. Otherwise, there is no ground available to reject such applications. Furthermore, the Supreme Court of India has affirmed the CIRP's exclusivity. In the case of Mohammed Enterprises Limited versus Farooq Ali Khan in the year 2025, the Supreme Court ruled that high courts shouldn't interfere with CIRP proceedings under Article 226, stressing that IBC is a self-contained alternate remedy framework. This ruling actually reinforces the exclusivity of CIRP process and the specialized role of the NCLT as being an adjudicating authority, limiting the forum shopping and parallel proceedings that could delay the resolution of a company. When can NCLT reject a CIRP application? 1. If no default exists, or if debt has not become due yet. When an admission is opposed due to an existing award in favor of a corporate debtor and that exceeds the debt amount, that could be a ground. And if the application defects aren't rectified within 7 days of notice from the NCLT, which becomes an incomplete application. In that case, NCLT can reject a CIRP application. Now, NCLT has limited authority to reject applications where default is established apart from these grounds. Let's dive into CIRP's recovery reality. Creditors recovered a record of 67,000 crore rupees through IBC in financial year 2025. And this is a 42% increase from financial year 2024, which was 47,206 crore rupees. And a total of 284 corporate resolution plans were approved, out of which 267 were corporate insolvency cases and 17 were personal insolvency cases. And this has fueled the recovery surge. Across all resolved cases, lenders recovered rupees 3.89 lakh crore against admitted claims of 12 lakh crore rupees, giving a 33% recovery rate. and this is a 67% average haircut. So to understand from this, these are the numbers which highlights the gaps between legal framework and the practical outcomes in CIRP process. So now to understand CIRP in practice, we do now know there is an interplay of sections, rules and regulations, and how judicial pronouncements have shifted from a mandatory to a discretionary approach. And despite increasing recoveries, there still persists challenges in maximizing the value of assets of the creditors. So thank you for staying till the end, and if this really helped you, let me know in the comments which topic I'm supposed to decode next. And if you really believe legal education should be practical and insightful, you know where to be.